I talk a little bit about the different types of LPA, we have two main types of LPA, the Form 1 LPA and the Form 2 LPA. Both are great tools, right, with their respective utility. The Form 1 LPA is a bit more restrictive, right? It would be suitable for donors who have perhaps quite simple or straightforward instructions and generally trust the donee to be able to make all the decisions on their behalf, right? So say for certain restrictions, specified restrictions, they are comfortable to give that power to the donee to make those decisions, even though how you might want those decisions to be made as a donor is not specifically spelled out, right? You have that comfort in that person, that donee, that the person will act in line with what you want, all right? So if you are, and your affairs, okay, are quite straightforward in the sense that you don't need any complex or major complex financial decisions or investment decisions to be made, then you can look at a Form 1 donee, okay? Now the downside is, of course, there are some restrictions, all right? For instance, you cannot appoint more than 3 donees. You can also not look at more than 2 replacement donees. But the benefit, of course, is that because it's quite straightforward and you can be guided by the form itself, you don't need a lawyer to assist you to actually draft Form 1, okay? So like I mentioned earlier, you are okay with the donee, you have comfort that the donee, while having wide-ranging powers, will be able to make decisions in line with your preference, and you only need to restrict them by way of specified restrictions, okay, which we'll talk about later. Okay, and then now we move on to the Form 2 LPA, which is a creature which is suitable for donors who want a little bit more control and guidance as to how their affairs are to be dealt with during this period of incapacity. Okay, you can have unlimited donees, all right, in respect of the 2 areas. And of course, unlimited replacement donees. And because it is a very bespoke legal document, you have to seek an assistance from a lawyer to actually draft it for you. Okay. Now, this Form 2 LPA is useful for donors who have very specific arrangements or thoughts as to how their finances are to be conducted, how their living arrangements are to be met out, okay? And you might even want to restrict some of your donee powers in implementing those wishes, right? So all this crafting, all these customizations can only be captured under a Form 2 LPA. So just now we mentioned under a Form 1 LPA, what are some of the general restrictions, okay, that a donee may not do, right? So a donee may not act if the donor has the mental capacity to make the decisions. This one we mentioned about earlier, right? As to whenever the donor has the mental capacity, then the donee should not act, okay? The donee, of course, must act in the best interest of the donor. This is very important, especially under the Form 1 LPA, where they have wide-ranging powers. So the guiding principle, right, in exercising those wide-ranging powers is that they must make it in the best interest of the donor, as deemed appropriate by themselves, okay? The donee must ask, okay, what would you have done? What would the donor have done, right, if they had the mental capacity to act? Right? Of course, they must be very intuitive. They must know your beliefs, your values, and your feelings and how you would normally act. So you need that person to be very, very close to you to be able to be a Form 1 donee. Okay? And also, if the donor has requested the donee take into consideration certain other trusted person's views and wishes, they should also consult that particular trusted person. So earlier we discussed about the general restrictions, right? Now we move on to the specific restrictions that a donee cannot do, right? And you can think of the specific restrictions as essentially hardcore carve-outs, which the donee will not be permitted to act on your behalf, right? So the first would be the donee, of course, cannot and should not restrain the donor, right? Unless the restraint is necessary to prevent the donor from getting seriously harmed, or maybe a life-saving act, and the donor must really seriously have a reasonable basis to believe that the action of the donor would bring harm to himself or herself. Okay, there should also not the donee will also not be able to make any decisions regarding life-sustaining medical treatment, all right, which prevents serious deterioration in the donor's condition unless this is specifically permitted under a Form 2 LPA. Okay. So there are other specific restrictions, all right. The donee may also not be permitted, okay, to essentially make any decisions on healthcare treatment and clinical trial, right, unless the donors specifically authorize the donee to be able to do so under the Form 2 LPA. So under a Form 1 LPA, this restriction will apply, right? You can't alter that. Another restriction, right, is that you are not permitted as a donee to give away any of the donor's property or to do a transfer, all right, unless, again, the donor specifically permits in the Form 2 LPA, right? So in the Form 1 LPA, this restriction will also apply without any alteration, okay? And of course, the donee will also not be able to make any decisions relating to nominating or revocation of any insurance or CPF matters. Okay. The excluded decisions are essentially a set of hardcore exclusions which fall outside even, right, of sort of like what is permitted to be acted upon on behalf of a donor, right? Again, these are very, very fundamental decisions relating to religion, to essentially organ donation, right? These are very hardcore fundamental liberties and freedoms which will be outside of the purview of a LPA. Okay, so briefly you can see it's in relation to marriage, religion, adoption of children, abortion, organ donation, and of course revoking AMD. Okay. So earlier we talked about the differences between a Form 1 LPA and a Form 2 LPA, and those differences will be more administrative in nature. Right? It's also important to understand the substantive differences between a Form 1 donee and a Form 2 donee, specifically if you have certain investment mandates or you have very particular instructions as to how your finances are to be carried out. Okay? The first major difference between a Form 1 donee and a Form 2 donee is in respect to the investment powers of the donees, okay? You recall in a Form 1 LPA, right, the Form 1 donee actually has wide-ranging powers to be able to make financial decisions on behalf of the donor, right? But in doing so, they are not to be able to act with an investment mandate in mind, so to speak. Rather, they are expected to make investment decisions more conservatively, okay? The reason is because their priority in making those financial decisions would be to preserve the donor's assets for his or her maintenance and welfare, right? And this position of making financial decisions more conservatively, right, is actually laid down in a court case, right, which sheds some light as to how the court sees the exercise of investment powers by donees, right? You contrast that with a Form 2 donee, right? A Form 2 donee can then, if it's instructed, if it's properly drafted in a Form 2 LPA, the donee is able to actually make investment decisions in accordance with the donor's wishes, right? And whether it may be aggressive or, whether it could be, a more sophisticated investment mandate, that Form 2 donee will be able to carry those out and even able to appoint specific investment managers or trust companies, okay, to essentially invest with specific investment mandate in mind, right? In terms of the people who can benefit under a the exercise of a donee's powers under a Form 1 LPA, generally speaking, right, when the donee access the funds of the donor under a Form 1 LPA, it is primarily to benefit the donor, right, and to deal with expenses of the donor's maintenance, right? It is not really intended, right, for the Form 1 donee to access those funds to benefit third parties. Okay, you contrast it with a Form 2 donee, right? If it's specifically drafted again, the donees are actually able to make specific funds, distributions of funds to benefit and maintain third-party beneficiaries such as elderly parents and dependent children, right? So that can be like no questions called as to whether there was a right use of the funds, of the donors' funds in be able to distribute to third-party beneficiaries, right? Okay. Next, we talk about the clarity of the donees' roles, right? Under a Form 1 LPA, many people think that, yeah, it's convenient. I will just give, I say, my daughter or my son their wide-ranging powers to deal with my affairs. But with that wide-ranging powers, it can also create ambiguity and also a lot of conflict, right? That's what we see quite often. So the beauty of a Form 2 LPA is that different donees can, under a Form 2 LPA, have very clear roles and powers to make decisions, okay? Therefore, reducing conflict. I mean, we put down here as business decisions, but it really can be decisions in any realm, right? And the Form 2 LPA, if you have a business, right, can also permit or empower the donee to be able to have clear powers to vote for you as a shareholder, if you maybe one, or to be appointed as a director in your stead in your moments of incapacity, right, if you are a director.